Hi, welcome back to Securities Regulation. We are now on lecture 15. Now, we've covered a fair amount of ground so far in preparation. We've covered the basics of contracts, the basics of property and company law. We've talked about some of the basic concepts that we'll be using in the IPO process and securities regulation in general. It is now time to move on and start talking about the IPO process. Now, if you will recall, the process or the procedure involved for a company to go public is one of three types of regulations or one of three methods that a securities regulator will use to regulate a securities market. The other two being eligibility criteria and disclosures. So now we are looking at the third method of regulating the securities market, which is the process. Now, when a company is going public, when a company is doing an initial public offering, it needs to go through a certain set of steps. What are these basic steps? Well, firstly, we file a draft Red Herring Prospectus with SEBI. And then SEBI takes a look at this and comes back to us with comments. Once SEBI comes back to us with comments, we then update the draft Red Herring Prospectus, which then becomes a Red Herring Prospectus. Then we get to file the Red Herring Prospectus again with SEBI as well as the Registrar of Companies. Once this has been done, we can then move ahead and open up the public issue or the public offering for the public to place their bids and applications. And finally, once we've discovered the price through the book building process, as we've discussed in the last lecture, we then put in the price into the prospectus and we file the prospectus. Sounds fairly simple, doesn't it? But each of these broad steps that we talked about has a number of smaller steps, beginning with the draft Red Herring Prospectus. Now, this is where us as capital markets lawyers, this is where we come into existence. This is where we start working. Now, typically, the first major event in an IPO is going to be the kick-off meeting. This is a meeting between the company, the merchant bankers, the lawyers, the auditors. And in this meeting, the company will introduce themselves and will talk about what business they're in, who are the promoters, who is in the management, what do they do, and how has the company fared over the last few years. This is known often as a kick-off meeting. At the kick-off meeting, it will be your job as the capital markets lawyer to hand over a document checklist or a requisition list. Now, this is a checklist that is maintained by most capital markets teams, and it changes from time to time. This will be a list of documents that you will require from the company in order to start your due diligence process. Now, the first few documents that any document checklist for a diligence should have is the incorporation certificate and the articles and memorandum of association. So we need to ensure that the company is in fact properly incorporated. That's one of the basic questions that you ask. And this document checklist could go into many, many pages. Now, I'm not going to go into what is in a document checklist. That differs from firm to firm, from team to team. But it is on the basis of this document checklist that the company will then set up a data room. Now, a data room used to be a physical space. Nowadays, it's mostly a virtual space where the company will place all of the documents and the data that has been required by the capital markets lawyers and the merchant bankers. But it is important to remember that irrespective of whether it's a physical space in the corporate headquarters or the registered office, or it's a virtual space where documents are scanned and uploaded, it is important to ensure that this space is secure. Now, because you'll be dealing with a number of documents that are sensitive or confidential in nature, you don't want that information getting out into the public. Now, based on the documents that you receive, you then carry out a due diligence. What a due diligence is will be explained in two other separate videos. But basically, a due diligence is an overall legal audit of the company, going into each and every aspect of the company to ensure that there are, or to discover that the legal risks or the compliance risks that are there in the company. Now, once you've done your diligence, you then start preparing disclosures. You start preparing the chapters that go into a draft red herring prospectus. And we've seen what the chapters are in a previous video. Now, once a number of these chapters have been prepared, we can then put them together, and now you have the first version of a draft red herring prospectus. Following this will be a number of drafting sessions. Now, in a drafting session, the company officials, the merchant banks, the capital markets lawyers, and sometimes the auditors too, will sit together around a boardroom and go over the draft red herring prospectus or its versions word by word, line by line. This is to ensure that everybody is on the same page as to what information is to be disclosed to the public. Now, mind you, in this offer document, in these disclosures, one must be as truthful as possible. In fact, any falsification, any misrepresentation can and will lead to civil and criminal liability. It could also mean various repercussions for both the capital markets lawyers and the merchant banks. Now, interestingly enough, there might be a number of events or situations in the company that may be detrimental to the reputation of the company, in the sense that if people found out that one of the directors was under investigation or under inquiry for, let's say, an economic offense, then that would be problematic in the eyes of the public. And the company will often say that, can we please not put it in there? We don't have to disclose it. So there's going to be every incentive from the company to not disclose negative news or negative things about the company, because it paints the company in a bad light. On the other hand, you know for a fact that under the Companies Act, any misrepresentation or any falsification of data in the prospectus does lead to criminal and civil liability. As a result, it's in these drafting sessions that we ensure that whatever is in the draft red herring prospectus is fair, accurate, and truthful. Once we've finished drafting the draft red herring prospectus and everybody's signed off on it, everybody's happy with it, we can then go ahead and file the draft red herring prospectus with SEBI. Now, all that I've mentioned so far, from the kickoff meeting till the filing of the draft red herring prospectus, this can take anywhere between 2 to 6 months or even longer if it's a very, very large company. Now, obviously, the volume of work depends upon how large the company is. And this is where drafting the draft red herring prospectus, this is where the capital markets lawyer is expected to do about 80% of her or his work. After this, things become a lot easier for cap markets lawyers. When we have filed the draft red herring prospectus with SEBI, that is our first indication or first intimation to any regulatory authority that we have filed, that we are about to do an initial public offering. Mind you, till now, we have not actually engaged with any of the government agencies or authorities on this. At the same time, when we filed the draft red herring prospectus with SEBI, what we also do is we file for an in-principle approval for the listing of our shares on the stock exchanges on which we want to list. Now, typically, the most popular stock exchanges in India are the National Stock Exchange and the Bombay Stock Exchange. But it wouldn't be unusual for a company to list their shares on these stock exchanges as well as a city-based stock exchange, such as the Delhi Stock Exchange or the Calcutta Stock Exchange. Now that we've filed our DRHP and we filed this in principle approval, the capital markets lawyers can sit back and heave a sigh of relief. Most of their work has been done. Now, the first thing that happens after the DRHP has been filed with SEBI is that SEBI will release that DRHP on its own website. The merchant bankers will do the same, and the company will also display the DRHP on its own website. This is to ensure that the public gets to know that this particular company is about to do an IPO. And now the public can raise objections as to the disclosures made in the DRHP, or about the veracity or the accuracy of the disclosures made. In fact, this is how the Sahara scam got unfolded or got discovered. Now, soon after you file the DRHP, you will receive an in-principle approval from the stock exchanges where you've applied for listing. A little while after that, the merchant bankers must share a certificate stating that they have received no complaints about the DRHP, and they must furnish this certificate to SEBI. SEBI will take about a month and a half, depending upon the size of the DRHP, to come back to the company and the merchant bankers with observations. Now, we might call them observations, but when SEBI tells you to change something, you will change it. So SEBI might have a number of suggested changes, such as this particular director's disclosure needs to be expanded, or this particular promoter's disclosures can be made more concise. Typically, SEBI will always have a number of concerns or a number of changes in the risk factors. Now, it might ask the company and the merchant bankers, and therefore us, it might ask us to merge two risk factors that are inherently related. It might ask us to demerge or separate two risk factors which are clubbed together previously. It might ask us to reorder certain risk factors based on what SEBI thinks is more important. The most important risk factors usually are in the top 5 or the top 10. So we go through all of that. We change the draft Red Herring Prospectus to make it in line with SEBI's comments. At the same time, the company in the last couple of months, since it has filed the draft Red Herring Prospectus, there might have been certain changes in the company as well, such as an update on litigation. New litigation might have come up, or existing litigation may have been settled. We will need to disclose that, or we'll need to update the draft Red Herring Prospectus with that information. More directors may have joined the company, have been appointed to the company. We will need to update the draft Red Herring Prospectus with that kind of information. Once we've updated the draft Red Herring Prospectus to make it in line with SEBI's comments and any other information that has changed, it is no longer a draft Red Herring Prospectus. It is now a Red Herring Prospectus, right? So now we have changed it. We have changed the document and made it as per SEBI's requirements. And then once we've done that, we refile it again with SEBI. SEBI will take about a day to go through the document and to confirm that all of the changes that have been carried out have been done so to SEBI's satisfaction. Once I have that go-ahead from SEBI, I can then file the Red Herring Prospectus with the Registrar of Companies. So effectively, when I'm making an initial public offering, this entire process of a draft Red Herring Prospectus is nothing but the securities regulator checking whether I am in compliance with existing securities laws. Once I am, then I can turn to the Registrar of Companies and file the final version of the Red Herring Prospectus with the Registrar of Companies. Now, once we filed the Red Herring Prospectus with the Registrar of Companies, I would say about 99% of the work to be done by the capital markets lawyer is done. Because the biggest work or the biggest challenge that the capital markets lawyer faces is the diligence and the consequent drafting of the Red Herring Prospectus. Now it's time to get the market aware and to beat up a frenzy over this IPO. So the merchant bankers will arrange to have the prospectus, application forms for the public to fill in and make bids or applications for these shares, and perhaps a smaller version, a more concise version of the Red Herring Prospectus, often known as an abridged prospectus. So the merchant bankers will have all of these issue materials printed and dispatched to various brokers, to stock markets, to clearing houses, to depository participants, and so on and so forth. It will arrange for the issue to be made as widely known as possible, and it will make it easier for people to apply for these shares. At the same time, the merchant bankers will conduct a series of meetings known as roadshows. Now, in these roadshows or in these marketing meetings, members of the company's management will meet key qualified institutional buyers. Qualified institutional buyers will have the opportunity to talk to the company's top management to try and understand what is going on with the company, what kind of business are they in, what are the future growth prospects. So through these meetings, the company can generate interest about itself, and the merchant bankers can ensure that enough qualified institutional buyers buy these shares, and as a result, the public offer is fully subscribed. Now, the only challenge is that the company management should not be telling qualified institutional buyers anything apart from what is already there in the draft in the Red Herring Prospectus. The reason being that I cannot hold the qualified institutional buyers at a higher advantage than the rest of the public. Therefore, whatever I am saying to the qualified institutional buyer needs to be as per the Red Herring Prospectus. Cannot give out any more information than that, right? Now, 5 days before the issue opens, we make an advertisement in various newspapers. Now, typically it's in an English national daily, Hindi national daily, and if the company's registered office is in a location or a state where Hindi is not the prevalent language, then an advertisement in a newspaper of that vernacular, right? In this advertisement, we announce the price band. We announce what is going to be the price at which the public can bid for these shares, and at the same time, we put down a 1% deposit. So 1% of the entire issue size is to be deposited to SEBI. Consider this as a security deposit, and that's when the issue opens. Once I've advertised for it and the public know that we have an IPO, then the issue actually opens and the public can now start putting in their bids and applications. Once the issue opens, the merchant banks need to submit a 3-day monitoring report to SEBI saying that there have been no complaints, or this is the level of interest that we've seen so far. Once the issue has closed, the registrar to the issue then tallies all the applications, weeds out the applications that are improper or incomplete, and runs the book building process. We already know what the book building process is like. Once I complete my book building process, I will have some information as to what is the final price going to be, who are the people who've been allotted shares and how many shares they have been allotted, and who are the people who have not been allotted shares. At this point of time, we can go ahead and file the prospectus. The prospectus is almost identically similar to the Red Herring Prospectus, except that the prospectus will have the final price of the shares in it. The Red Herring Prospectus will not have the final price because the issue hasn't opened and book building hasn't been done. But the prospectus is after the issue has closed and the book building process is over, and therefore we know what the price is. Once we file the prospectus with SEBI and the ROC, we can then issue and allot these shares to whoever had an allotment, and we can return the money we can return the money to those people who have not been allotted shares. In case of ASBA, we can instruct the various banks to release that blocked amount, right? And finally, once we've issued and allotted all of these shares to the allottees, we can then go ahead and list these shares on the stock market. People who've been allotted these shares can now start trading in them on the secondary market or on the stock market. So this was a broad overview of the process by which a company can do an initial public offering. This process is more or less the same for a further public offering as well. You'll notice that much of the job of the capital markets lawyer lies in the due diligence process and the drafting of the DRHP, which means that our job as capital markets lawyers lies in the first sort of one half of the entire IPO process, right? In the next video, we'll start with what goes into the draft Red Herring Prospectus.